You're here.
Yes, sir. Well, one matter
Yes.
which was fixed by the court on 9th of February 2026
Hmm.
is a criminal petition.
Hmm.
E-court it was showing
Hmm.
that it is fixed on 9th because I came here and it was fixed on 9th.
Hmm.
It's a criminal petition.
Hmm.
But somehow when we came here in the court, we found that it in the list it is not there.
Ha.
So now if it is not inconvenient to your lordship, because there is an interim order, it is against the state, criminal petition for questioning of an FIR.
Hmm.
I have been protected. So if the matter is listed, my lord, and some protection, the interim order may continue. This is criminal
Tomorrow.
petition
It will be listed tomorrow.
43 of
It will
2025.
be listed tomorrow.
Tomorrow.
It is fixed. In fact, it was fixed today.
Today. That's why we came from
So,
Gauhati.
Madam has to go.
And I have to go to Arunachal Pradesh also. my lord.
Madam had to go.
That's why. If it is not inconvenient today or, my lord, if it is not inconvenient to your lordship.
Tomorrow it will be listed.
Tomorrow.
Hmm.
This is the order, my lord. Kindly see the order of this court.
It's okay. It will be automatically. Because if it's not listed, what can we do?
That's only it can be listed, my lord.
Tomorrow, it will be listed tomorrow.
Yes. Because we were under impression the e-court, we normally see that.
Hmm.
And it was fixed on 9th.
Hmm.
And it was the parties, both parties, the matter was fixed.
Madam had to go to Delhi, so
No, it's okay.
he's on leave. It should be listed tomorrow.
Tomorrow.
Ah.
Yes.
Or you ask your junior to give a mention memo for,
Yes.
for tomorrow.
I'll ask.
There's an option.
Yes.
Lordship, similar is the case. It's a matter was listed
You
in
just
e-court.
give-
It will be listed tomorrow. Yes, sir.
You just give the mention memo.
Yes. And I guess so. The interim order is still today. So
It's
we'll
okay.
write
No,
on it.
no issue. It's
Okay.
not your fault. It will be extended automatically.
Lordship,
Yes, sir.
item number 3.
Ha.
Lordship, the affidavit filed by the state respondents,
Hmm.
I received just now inside the courtroom.
Ha.
So, Lordship, I require a short period to go through and file a reply affidavit.
Okay.
So, about a week's time may be given.
On the prayer of Mr. T. Takamasa, senior counsel for the petitioners, let this matter be listed after a week.
Yes.
2 weeks. 2 weeks. I'm for the Union of India.
2 weeks.
3 weeks.
3 weeks. Have you filed your affidavit? Have you filed your affidavit?
I received a letter from the department that they will be seeking some time.
What is your role? What is your role as a
I
union?
for my affidavit, Lordship.
Now, what is your role in the matter?
Because we are praying revision of salary from the state.
Okay, huh?
We
Yes.
have been met the parties on it.
Actually, the state is in respondent since affidavit.
So why union is a party? Why they?
My lord, what has happened is in the earlier round of litigation,
Mhm.
my lord, we did not implement because this is the third
Yes.
round of litigation. So in the earlier round of litigation, it was a desire of the division bench that Union Media also should be implemented as a party. According to the direction of this honorable court, it was implemented because the stand of the state government was that the salary paid to us, the honorarium paid to us is recovered from the Union of India.
Acha.
That's how they were implemented.
Okay.
Otherwise, my lord, we are praying from the state government. And affidavit is fine.
Our party is only a manager part.
Ah.
The fund released by the Home Department, Home Affairs, we manage from here. So we are manager. So without the Union of India, I think the president will not
It's okay. In
take up.
that case, let them
Yes.
file since they are a party. So no. Then in that case, you just write Mr. Takamasa, senior counsel for the petitioner, submits that he may be granted some time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Mr. Yangarbati, Landis CGC, also prays for some time to file affidavit in opposition on behalf of the Union of India. Stuff. Considering the submissions and the issue involved. Let this matter be listed after 3 weeks.
Lordship, may kindly give us a date
In
if
the-
it is convenient.
In the meantime, the parties may exchange their pleadings.
Lordship.
You just
Give us the book, please.
7th April.
7 April. Huh?
2nd April. 2nd
Uh,
April.
Listed
That is
by-
after 3 weeks.
not on 1st April.
Yes, Lordship.
Why not on 1st April?
Okay, no problem.
I'm just saying. I am not letter not only.
Lordship.
What is 1st April?
Witness April full up for his witness, Lordship.
Second April.
Lordship.
I don't want you to make everyone full.
Lordship. Yes.
Worship,
Please.
I beg to mention item number 5.
Yes.
Here I'm yet to receive an instruction. So
See.
3 weeks time we will grant.
On the prayer of Mr. Interim London Additional Advocate General for the state, further 3 weeks time is granted to file affidavit of opposition.
Interim order may be.
Interim so and so is present for the petition. Interim order passed, earlier shall continue.
Please, Your Lordship.
Yes.
Your Lordship, I may be allowed to adjourn hearing item number 11 on behalf of the council for a petitioner.
No adjournment.
Sir,
Hearing no adjournment. Sorry. What happened?
he is under medical treatment.
We'll try. You give the second file to her. You read it. We have enough time. How long it will take for you to read the file?
Actually, I am, my name is Linda Goslis.
It's okay. No issue. We'll allow
On
you.
behalf of the petitioner.
Will allow, give her the second file. Try it. If any difficulty, we'll adjourn. If he's in the medical, problem. Yes. Take the second file, read it. Yes, next.
My quick mention, item number 8.
8.
Yes, Lordship, after 2 weeks, Lordship, we have to file my affidavit
Item 8.
for the resolution 1 to
Why
4.
this is listed for orders? Why this is listed for orders? For filing affidavit.
Yes, Lordship.
Let's see. Item 8.
Also, they will not also file the
Then,
Yeah.
Mr.
May I please, Lordship?
Mojamed, learn
Uh,
counsel for the petitioner.
May I please, Lordship?
Yes.
My lord, here I'm appearing for response number 5, 6, and 7.
Ha.
I have received instruction, but I sought some clarification, my lord. So can I allow me 3 weeks time?
On the prayer of both Mr. Yangerbati, under CGC and Mr.
For the state.
For the state, learn counsel for the state. Come on. Further 3 weeks time is granted to file their respective affidavits in opposition.
2 weeks, Lordship.
2 weeks. 2 weeks.
3 weeks, man.
3 weeks. Because it's of no use fixing it if they cannot file it.
Much obliged.
Mr. Lordship. Lordship, I beg to mention item number 2 on behalf of Ace Chan. Kindly grant 3 weeks time to file affidavit.
State.
Lordship.
Mr. L. Likase Sanctum learned counsel for the petitioner. For the 3 weeks on the prayer of MS
Bichano on behalf of Ace Chan.
learned counsel, state counsel. For the 3 weeks time is granted to file affidavit in opposition.
Your Lordship.
Yes.
Lordship, I may be allowed to mention item number 4, Your Lordship.
Hmm.
Your Lordship, may kindly grant me 1 week's time to obtain instructions, Lord, with regard to the status of the case of the petitioner, Your Lordship.
What is the matter here?
Your Lordship, here,
No payment of selling.
Your
You're
Lordship,
supposed
here-
to. You said you have some. You have said something on the
Yes,
last
Your
occasion.
Lordship, the matter is under process, but I have not received the official information as to the present status. So I may be allowed a week's time so that I can gather the information.
Heard
and
Mr. So learned counsel for the petitioner. MS.
In the holy, Your Lordship.
London State Council submits that the grievance of the petitioners are under consideration. However, she has not received the latest status of the matter. Therefore, prays for a week's time to obtain instruction. This stuff. Prayers allowed. That this matter will be listed after a week.
Wait. Much obliged.
To so as to enable the MS so and so to obtain instruction.
Yeah, this Lordship.
Yes,
Your Lordship, I beg to mention item number 6.
yes.
Your Lordship, I got the counter reply only today, so I may be granted 3 weeks to file my.
What is the matter?
Your Lordship, it's regarding payment of paid salaries.
You are illegal appointees, according to you.
Yes, Your Lordship.
So that's why you are not paying. I mean, they have been terminated.
No, they have been done.
Okay. But then you have to pay the periods for the periods which they have worked.
They have not worked also, Your Lordship.
Huh?
They have not worked also, my Lord.
Okay.
For the period that they are seeking
Ah.
payment of the salary.
Before termination.
Before termination.
How you do know?
Because, Your Lordship, there is the notification will be issued by the government not to let them continue with their works until and unless their names are being cleared
Before the termination.
before the termination.
How many months?
Your Lordship, my sincere apologies. I do not have the brief of the case with me.
For how many months they are claiming?
No, Your Lordship, for about more than a year, Your Lordship.
More than a year.
Yes.
Great for employee.
Yes, Your Lordship, great for it.
Have some mercy on them. Be gracious, you are a welfare state.
Your Lordship,
At least if they claim that they have worked, pay them.
yes.
Terminations, okay, we may not like to we are not inclined to interfere.
Correct.
But the period which they have served,
Yes, however, Your Lordship, it appears that they have not, they have been stopped from the performing their duties, yes, as per notification. So it is good. Anyway, Your Lordship, let them file, Your Lordship, because today is
I will direct you to pay. There's a period which they have served.
No, Your Lordship.
Will not interfere with the termination.
They have not served, actually. They have not served.
MS so-and-so learned counsel for the petitioner submitted the affidavit in opposition. No, the affidavit in opposition on behalf of the state has just been served. Has been served today only. Therefore, she pressed for some time to file affidavit in reply. Therefore, she pressed for some time to file affidavit in reply. Praise the Lord. Let this matter be listed after 3 weeks.
Yes, Your Lordship.
I wanted to give you a relief, but you don't want. Let's take for it. Huh?
I'm deeply obliged, madam.
Much obliged, Your Lordship.
Motion, item number 1.
What is the order was passed? Date of order?
Pardon, Your Lordship.
When the order was passed? Date of order?
Passed on 25/9/2023.
25/9?
25/9/2023.
Contempt of Courts Act, Section 20. When did you file this affidavit? I mean the contempt petition.
Yes.
When did you file?
3rd of this month, 3/3/2026.
Section 20. It's barred by Section 20. Hit by Section 20. Section 20. Read Section 20.
Limitation of action for contempt. No court shall initiate any proceedings of contempt, either on its own motion or otherwise, after the expiry of a period of 1 year from the date on which the contempt is alleged to have been committed.
So, from which date you are claiming that the contempt has been committed?
So, Your Lordship, we have issued notice as advised by the court. Thereafter, we have even written representation. Thereafter, then only we have issued them a contempt notice. However, 8 months have passed by after that contempt notice have been issued. However, no positive responses have been availed till now. That is why with no other option, we
From which date? From which date?
It was, we have given a contempt.
Is it
notice-
within one year?
No, we have given the contempt notice on 3/6/2025.
No. From which date you are alleging that the contempt has been committed?
Is the, we're alleging the contempt has been committed since 14/11/2023. How, because that was the day we have given the notice.
So is it within 1 year?
No, Lordship, the time has lapsed, but however.
Then
Yes,
forget about the date of order, right?
yes, Your Lordship.
But then from the date which you have alleged to have committed the contempt,
Yes.
from that also it's more than 1 year. What can we do? I think you have missed the train.
My Lordship, if this could be.
We'll see. We'll issue notice, that's all. But this will not be on next date. The alleged contempt, surely they will raise this issue. Correct.
Yes, Your Lordship.
Third MS, so and so learned counsel for the petitioner. This is an application under section 12 of Contempt of Court Act 1971. Read with Article 215 of the Constitution of India and the Gauhati High Court so and so. That is 77 something like that. You find out. What is that Gauhati High Court contempt rules? Gauhati High Court contempt rules 1977.
Well, I'm not so.
It's your petition.
Yes, Your Lordship.
Although in the section 12 of the Contempt of Court Act 1971, but the rules, we have the rules. So that this should be regulated, this proceeding will be regulated by that rule only. And we'll give, you find out, Gauhati High Court's Contempt of Courts rules 1977, something like that. We'll find out. Issue notice, alleging violation of willful disobedience and violation of order dated 25/09/2023, passed in WPC 227 of 2021. List of issue notice returnable by 4 weeks. Learned counsel for the petitioners to take steps for service notice upon respondent number, Alice container number 1 and 2 by speed post as well as usual process within 2 days.
Much obliged, Your Lordship.
List after 4 weeks.
For motion, item number 7.
May I please, my lord? Lordship, this matter is handled by my learned friend Arjun Lee. Lordship, he is disposed. However, I've been informed that Your Lordship, the affidavit is yet to be filed by the state respondent. So if some time can be kindly be granted, Your Lordship.
So this the claim is on the basis of the scheme 1703/2015.
Correct, my lord.
Still in vogue.
Yes.
Then
Yes.
we'll pass the order. Allowed, writ petition allowed. You consider. Similar order, last week passed a similar order. Same.
Lordship, since I don't have the brief with me, if this matter can be listed tomorrow, my lord?
No, today. Dispose of. After some time, give you take this.
Lordship.
I think last week we passed in the order on the same issue. Regulation of service. Same exact. They have been released after serving 35 years.
Correct.
When his matter was his case was forwarded, he did not complete 30 years,
Correct.
20 years.
Correct.
So there is a clause. Clause 1 say you will have to complete 30 years.
Correct.
Right.
Yes.
on 15/1/2015.
15, yes, my lord.
But then there's another clause. Even if you have not completed by that time, still working,
Yes.
then on completion,
Of 30 years.
30 years,
Yes.
you have to regularize.
Lordship.
Now they have been particularly will not we have not grant any particular thing, the area salary and all, but we said for the purposes other, service benefits,
Yes, my lord.
basically for the pension,
Yes. Yeah.
regularize it. Because you have your own policy.
Yes, your lordship.
It's very clear.
Yes. Fairly said by this honorable court, your lordship. However, I
Yeah.
don't know whether yes.
I have this court has disposed last week.
Yes. Only one submission, your lordship.
Yes.
I don't know whether the council appearing for the state has actually received any instruction to that effect or not.
Doesn't matter.
If it can be listed tomorrow, your lordship, because he may have received some instruction that in that case, your lordship.
No, tomorrow we'll have other cases. There's no case tomorrow.
No, there will be, your lordship, but
Then-
if this can be listed in the subject
Only
list,
for
your lordship,
Kolhar? Who is appearing?
Ajungli, your lordship.
Where she is?
Your lordship, he's in disposed today, my lord.
He.
Yeah, yes, my lord.
Call him. Over the phone.
Lordship, he.
See, similar matter, why we necessarily keep it pending?
No, I agree, your lordship, I agree, my lord. However, if for the convenience of all, your lordship, if it can be listed tomorrow, my
We'll
lord.
take it up at 2 o'clock. I'll give you the copy and you take the file also. Find it out. If there's any difficulty, we'll accommodate you. Accommodate.
Lordship, my humble submission, if it can be listed tomorrow, my lord.
No, today. Similar issue.
That I agree, your lordship, but since I am not the one who is handling this matter, my lord,
You handle it now.
it is just a day adjournment I'm
There is
seeking, my
nothing.
lord. I understand.
There's no complication. You
Yes.
have your own policy
Yes,
scheme.
that I completely agree with my lord.
Unless you have done away this scheme,
Yes.
you have to abide by it.
I completely agree with my lordship. However, I don't know whether any instruction has been received by
Talk to him over the phone.
lordship. My humble submission, if it can be listed tomorrow for
On the
final
pre-
disposal.
On the prayer, Mr. N. Angame,
Lordship.
senior government, let this matter be listed at 2 o'clock. Yes, 2 o'clock we'll take it up.
Okay, your lordship. I'm obliged, man. Lordship, if the second copy can be yes, given to me.
You take whole file.
For him, item number 9.
Please, Lordship.
Yes.
Lordship, by this petition, I'm challenging the appointment of respondent number 3, Lordship.
Hmm.
He was appointed on 24th February 2020, Lordship. Page number 27 of the writ petition.
27.
27, Lordship.
Yes. As per government's approval, so and so, Sri Bumin
Yes, Lordship.
is hereby appointed as Chowkidar against the demise vacancy of Sri. Yes.
Lordship, my
Ready? Are you ready? Okay. Private respondent is there. Okay.
Lordship, we have already exchanged the pleadings, Lordship.
Yes.
My ground of challenge in this writ petition is, Lordship.
Hmm.
The first is the appointment of the primary respondent number 3 was without any selection process, Lordship. Second, Lordship, the petitioner, Lordship, he, being a landowner, Lordship, he has submitted an application before the authorities against the resultant vacancy on the basis of land ownership, Lordship. I have also enclosed the supporting documents issued by the concerned authorities stating that I am one of the landowners. Whereas my application was not considered, that is my second ground of contention, Lordship. The appointment, the post is a grade 4 post. It's in the Department of Soil and Water Conservation.
How the private respondent has been is appointed?
Lordship, the state they have
He is
already.
also so claiming on the basis of land ownership.
No, Lordship, he is not a landowner.
Then
The only contention raised by the state respondent is that formality has been followed. No reports in the affidavit. Whether advertisement was issued,
you have donated or your parents have donated?
my ancestors have donated, Lordship.
From where do we get it?
It was in the year 1994, Lordship.
Where
There
it
are
is?
some documents, Lordship.
Where? Show us the documents.
Yes, Lordship. If you also kindly come to page 20, Lordship. Page 20.
Yes.
Page 20, Lordship.
Hmm.
This is issued by the Chief Ang of Yangyang. This is a range under Mon District, Lordship. Yangyang is a range, Lordship, and under this range there are 11 villages, Lordship. Now the contents, Lordship. The villages under so and so ranged visit Mon Nagaland are as under so and so. Now the petitioner belongs to the village at serial number 6, Lordship. Nithung village.
Nithung village.
Yes,
Yes.
Lordship.
Hmm.
The headquarters under Japuga range, Tizit Mon Nagaland. Number 1 is Tizit Town. This is the ADC headquarters, and the second is ESA headquarters. Now, this establishments, this offices were established on the land donated by the villagers of this 11 villages, Lord. Privileges, facilities, job opportunities, and duties and responsibilities shall be enjoyed and owned by all the citizens of the villages under so-and-so range. So this is issued by the Chief Ang of the range, Lordship. Now, if the Lordship may kindly come to the next page, page 21. This is issued by the Additional Deputy Commissioner, Visit Mon. Made it, Lordship?
Who is the Noklong Konyak is who?
The petitioner, Lordship.
Okay. Son of so-and-so, landowners of Tizit Town. The office of the SDO Soil Conservation is situated in the land donated by
So this is issued by the administrative act of Tizit Town, Lordship.
it is one of the village under Young and Jacoba and landowners of Tizit village. And is situated in the land donated by Yangnin Jabuko Ranch citizens. Okay. What I'm trying to say is you are from Nithong village.
Yes,
who have donated
from
the
Nithong
land
village, Lordship, yes.
for establishment of this SDO.
Yes,
I
Lordship.
mean the Tizit Township.
Yes, Lordship. As well as more particularly, Lordship, the office of SDO Civil and Water Conservation.
Okay. Then
And the vacant post arose in this department, Lordship.
when?
Lordship, in the year 2020, Lordship.
And you have donated the land?
Yes, in the year 1994.
94.
I've
Any agreement?
No, Lordship. There was no written agreement, Lordship. There was only an oral agreement between the government and the respondents, Lordship.
Where it is page 23 is what? Allotment of 8,500.
Yes, Lordship. Page 23. This is an allotment by the district administration to the department, Lordship.
Okay.
After acquiring Lordship, it was allotted to the department for establishment of the office.
So for subdivision SDO soil
Yes,
and
Lordship.
conservation.
Yes, Lordship. Now, Lordship, page number 24 is the application of the petitioner.
Recommendation certificate.
And recommendation certificate.
Why was recommendation by whom? Chief Ang.
Chief Ang, Lordship.
What is Ang?
Lordship, this is a peculiar system.
Ang or Ang?
Ang, it is Ang.
Ang.
Yes, Lordship.
What is this?
Now he is the chief of all this, Lordship.
What is Ang? I'm just asking. I want
the
to.
head of a village, Lordship.
Okay.
And it also comprises of several villages, Lordship, and
Ang.
one Ang, Lordship. Yes.
Is it a local language?
Yes, Lordship, for our Konyak brothers, Lordship.
So In English, how you
under Molton district.
how do you, I mean, translate this? What is the meaning? In English or Assamese or Hindi?
Lordship, it is in their local dialect, Lordship. It can be as chief, village chief, Lordship.
Chief is there.
Yes,
I'm just asking. Ang
So
is a village or a community, something like that.
No, Lordship, it is a title given to a chief, Lordship.
Okay.
So he is the chief of several Angs, Lordship. And
Then Chief Ang again, no objection.
no objections.
Say Noklong Konyak so and so to the post of Chokidar against the existing vacancy of year so and so. So the memorandum is page 18.
Yes, Lordship.
Notification.
This is the policy that's holding the field.
So your case will fall under clause 3B.
Yes, exactly, Lordship.
Claim per so and so of oral agreement.
Yes, Lordship. In the
Where you have stated that there was an oral agreement.
Lordship.
Claiming empresses so and so, so and so. Have you made any statement? There was an oral agreement.
Yes, Lordship. May I read the policy first, Lordship? The notification 3.
No, your oral agreement.
Lordship.
Have you made any statement in your petition?
Lordship, may I read it from paragraph 7 in that case, Lordship? Starting from paragraph 7.
Not from 7, you just give the relevant paragraph.
Yes, Lordship. These are the relevant paragraphs.
I have donated the land for establishment so and so, more particular for sitting of so and so, to subsidiary statement, so and so, where research service so and so must be done. One of the village owners. There's no dispute. I situate how buses tracks were not not about it. Lot of land measuring so and so to so and so. And no other second setting of something.
Specific affirmative paragraph 15, Lordship.
15.
Yes, Lord.
So and so payment result agreement. As a result of oral agreement can be considered. No. What does it say that there was an oral agreement?
Yes. In the instant case, Lordship, the second sentence, the fifth line of paragraph 15.
There was an oral agreement between landowner and so providing service when the person landowner for difficult. Hard to believe.
Lordship.
Anyway, yes.
Bless your Lordship. Lordship,
Thank you.
the ICO office Moon Disease was established on the basis of land permitted by the additional deputy commissioner, Lordship. And Lordship, there was no oral or written agreement between the department and the landowners to give credit for appointment to the petitioner on the basis of land ownership, Lordship. And Lordship, Lordship will kindly come to affidavit batch number 3.
Affidavit
Lordship,
of affidavit of
for the state, Lordship. Paragraph 7, Lordship.
just respondent number
1, 2, Lordship. 1 and 2.
yes. Para 7.
If I may be allowed to read, Lordship.
Yes.
Paragraph 7. That with regard to the statement made in paragraph 7 of the writ petition, the answering Back states that the petitioner might have been a native of Nitung village under Japong range, Yan, and the Nitung village might have been of the landowners for the establishment of these services. However, there was no such oral or written agreement between the landowners and the department to give any credit for post to the petitioner by the Soil and Water Conservation Department.
Yes.
Lordship, that's my full submission.
That's all.
Lordship.
Nothing. How you have appointed her? Appointed the respondent number 3? He or she? He.
Yes.
Respondent number 3. Yes. Huh? Have you said anything on this?
My lord, the respondent number 3 is an indigenous inhabitant of the district of Mon, and as per the OM of
No, I'm just asking the government. I'll come to you. Just wait.
On the basis of government approval, the respondent number 3 was appointed, Lordship.
Simply. What is the basis? What is the basis of approval? How the posts are filled up? Just you get the approval and you just appoint. Is it so? Was there any selection process?
Lordship, no record, Lordship. For that, I have to you, Lordship.
Take. So you have not said anything on this except to say that on the basis of the approval of the government, the respondent number 3 has been appointed.
Lordship.
That's all.
Lordship.
There's nothing on record to show that any selection process has been was undertaken. No, nothing. Yes. Yes, sir.
Please, Lordship.
Huh.
The petitioner is claiming to be the landowner, but here there's no agreement or written agreement nor any oral agreement.
How do you know that there is no oral agreement?
My lord,
What do you mean by oral agreement?
My lord, this is the second round of litigation. This is the second petition that the petitioner has filed. In the earlier petition,
Forget about earlier. That was withdrawn.
No.
It was allowed.
though yes, but in that case, he claimed to be the recommended candidate, not as a landowner.
No, that was been withdrawn, permitted and allowed to file fresh. Right?
Yes,
So
but there he was.
don't go back to.
Yes, but in the absence of any agreement, because
When they say that oral agreement, then how do you say that from where you will get the document?
the department is saying that there is no written or oral agreement also.
Simply saying will not do. When you are not brought with the records, supports with the record.
And then even as per the application also, my lord, as per the
How you are appointed? Tell us.
my lord, having learned that vacancy is available,
Ha.
and I being an indigenous inhabitant of Mon district,
Ha.
as per the, I have applied for the post.
He is not.
He is also one of the. He is also.
Yes.
I'm not denying that.
Ha.
So
Then
I applied for the post.
you are not disputing that he's a landowner for establishment of this.
I'm not disputing that he is also an indigenous inhabitant of Mon district.
Ha. What about the donation?
Donorship.
There's a document to
He
show-
may have been one of the donor, my lord.
Ha.
But there is no agreement on record to show that there's an agreement regarding.
That's why he said oral agreement. There's a provision under the
Yes,
notification
I agree that, man.
that if
When
it
the
is
state
any.
councils are saying there's no oral agreement, man.
Obviously, they will say they don't want to give in. They want to appoint you, and then they have appointed you. You tell us how you have been appointed.
Well, I said that having learned that vacancy is available, I applied for the post, and then on being approved by the government, I was appointed.
Surprise.
And being an indigenous inhabitant of that
We
district,
will not allow this. If the post cannot be filled up on the basis of the land ownership, let there be open competition.
yes.
Set aside. Your appointment is set aside. Will not say that your case may be considered
Lordship.
to a vacancy
Lordship.
for land ownership
Lordship.
as per the
Clause 3B.
not clause 3B.
Lordship.
They'll consider it.
Lordship.
We cannot direct you to appoint.
Yes,
Consider it.
Lord.
And if the vacancy, having found that the appointment of the respondent number 3 is not in accordance with the law
Lordship.
or as per the selection process, will interfere with it, but then will allow the government to fill it up as per the law
Lordship.
by allowing everyone open competition. All right, that would be better. Kya kare? No,
Yes, Bishop. We'll do that.
law is not supporting you, right?
Yes.
Okay.
For all cases, as Lordship has rightly pointed out,
Hmm.
if 3B can be invoked, Lordship, and
We'll
because-
see. Let's suppose if there's no vacancy, you cannot force them to appoint you also.
Lordship,
There must be a vacancy.
against the post
certain-
by the
no.
private respondent, Lordship.
Why
Because
is it- why is
the
it-
government is admitting that there was no selection process, Lordship.
No, it's not that. See, the certain post has to be earmarked for. There's a system.
Lordship.
Say compulsory appointment.
Lordship.
A certain percentage is reserved for that.
Yes, Lordship, I agree, Lordship. In the
So likewise, in the even for this, you cannot fill up all the posts
Yes,
of
Lordship, I
grade
agree.
4
I agree, Lordship.
on land ownership basis.
I agree, Lordship.
That will be reverse, discrimination.
I agree, Lordship.
All right.
3B may be invoked, Lordship, and record the statements of the district administration as well as the concerned officer of the department, Lordship. And if the deputy commissioner finds that I'm one of the landowners, direction may be issued, Lordship.
No, not that way. Okay.
A similar case is there, Lordship, if I may be allowed to rely upon, which is reported in GLT 2020 Volume 2, Lordship, if I may be allowed to rely upon. 2022 GLT 309, Lordship, 903. Lordship, I'll read only 2 paragraphs, Lordship. A similar seriatic case, Lordship. It's in the district of Okha, Lordship. Paragraph 5, Lordship, will find page number 904. Paragraph 5, may I read it, Lordship? The state respondents have contested the case by filing a counter affidavit wherein the fact that the land where sub-center has been established so was donated by the grandfather of the petitioner have not been controverted. The state respondents in the counter affidavit further contains that clause 3B of the notification, which governs the appointment to be made on the basis of land ownership, prescribes that if there is any claim for providing employment as a result of oral agreement, the department concerned shall refer the matter to the deputy commissioner of the district concerned, who shall examine such claim, including whether any employment or any other facility has been given in the past. Accordingly, the department letter dated so had written to the chief medical officer and the deputy commissioner of Gauhati district, requesting to identify whether any appointment in grade 4 post was given to the landowners or to the descendants of the landowner in medical sub-center village under under establishment of CMO Gauhati. The CMO white letter dated submitted a verification report stating that the real landowners and the descendants were not given any grade 4 post till date. The Office of Deputy Commissioner, white letter also submitted its verification report stating that the read petitioner family who are the real landowners were not given any contract work or grade 4 appointment till date. Such exercise can be done, Lordship. Because as far as the affidavit of the state is concerned, no such exercise has been done, Lordship. And my ancestors have donated land in the year 1994, Lordship. The government has taken it free of cost. No, I have not enjoyed any benefit arising out of it, Lordship. And in this case, the report was submitted by the Deputy Commissioner. Basing on the report, a direction was issued by this Honorable Court, Lordship, to appoint the petitioner in that case. Because the finding of the Deputy Commissioner was very clear, Lordship.
Saying what?
Is
there any recommendation in your favor? No.
Lordship.
Is there any recommendation in your favor?
No recommendation as of now, Lordship.
Only to show that you are the one of the landowners.
Yes, Lordship.
Or is that so?
The verification can be conducted by the Deputy Commissioner, Lordship. Such exercise.
Heard Mr. Moajamid, London Council for the petitioner, and also heard MS
General for the state.
for London, the state, London government advocate for the state respondent number 1, 2, 3, 1 and 2, as well as Mr. London Council for respondent number 3.
Yes.
Next paragraph. By filing this writ petition, the petitioner has put to challenge the order dated order number so and so, page 27. Dated 24/02/2020, passed by the Director Soil and Water Conservation, Nagaland. whereby the one Sri Bumin, respondent number 3 herein, has been appointed a Chokidar class hyphen Roman 4, capital Roman 4, non-gazetted. No. Roman 4 against the demise vacancy of Sri Yai E. Konyak and the establishment of Director of Soil and Water Conservation, Nagaland. List of next para. Petitioner. The case of the petitioner, in brief, is that he's one of the landowners of the land donated for establishment of what? Establishment of
The Office of SDO Civil Soil and Water Conservation.
or as the office of the, where do you get it?
Okay. It's also there in the appointment of the lordship.
For establishment of the office of the SDO, Soil and Water Conservation, TIGIT, MON, Nagaland. List of on the request of the state of Nagaland, request of the government to the landowners of Jaboka Range within bracket, Yangian bracket close. And then under Mon district for establishment of Tejit Circle headquarter, the 11 villages under the said range has agreed to donate their land free of cost with a condition that in the event of any grade 4 post arises in the department, the service benefits would be provided to the landowners. List of in the year 1994, a plot of land measuring an area of 8,500 square feet was donated to the government by the landowners of Jaboka Range for setting up of the Office of Soil Conservative, Office of the Department of Soil Conservation at Digit. List of the additional deputy commissioner by an order dated by the communication dated 21/11/1994 had conveyed to the SDO, Soil Conservation, SDO. What is that letter?
Lordship will find it, please. Lord.
21 or 23? What is 23?
21 is issued by ABC Lordship, and 23 by the same authority Lordship. This is about allotment though.
What is it? SDO soil, huh? SDO soil, Digit. Regarding the allotment of that said land for establishment of the office of the SDO. This stuff. It has been established.
Lordship, yes.
Accordingly, the office of the SDO has been established on the land donated by the landowners, including the petitioner. This stuff. It is the contention of the land council for the petitioner. No, it is the contention of the petitioner that since the state has a policy to appoint the landowners to a grade port post in lieu of the land donated free of cost, land freely donated for establishment for government establishment. The petitioner, being one of the landowners, is entitled to be appointed on the great to the great port post, including the post of Chowkidar, which has fallen vacant due to the death of the earlier incumbent. Stuff. Before that, you write, huh? Before that, you just mentioned the petitioner being one of the landowner has approached the respondent authorities. When did you approach?
In the year 2019, Lordship. Immediately after the
There's no
post failed vacant, Lordship.
Your representation doesn't indicate any.
Application is dated new, Lordship. However, I have stated that I'm submitting the application against the vacancy.
What is it? Before the last paragraph, huh? You add this. The petitioner being the what is it? The element of landowners. One of the landowners, particularly particularly the Director, Soil and Water Conservation, Government of Nagaland, for appointment to the post of Chokidar against the vacancy caused due to death of earlier incumbent on 02/11/2019. Stuff. However, the case of the petitioner has not been considered. Then that it is a contention of petitioner, you add that. Then you write, Mr. Mohammed Land counsel for the petitioner, while referring to the documents, particularly the documents with regard referring to the certificates issued by the Chief of Ang of Yangyent, Tijit, Mon submits that, and also the and additional deputy commander Tijit, Mon submits that there is no dispute that the petitioner is one of the landowners of Tijit town, particularly particularly the land on which the office of the SDO, Soil and Water Conservation, Tijit, has been established. The state having the policy of the policy of the scheme being notification dated 05/03/2018, particularly clause 3B, where it is provided that if there is any claim for providing employment as a result of oral agreement, the department concerned shall refer the matter to the deputy commissioner of the district concerned, who shall examine such claim, including whether any employment or any other facility, including contract or supply order, has been given in the past, by taking evidences and by obtaining written statements from all the stakeholders, the respondent authorities are duty bound to consider the case of the petitioner for appointment in terms of the said notification. Next paragraph. Mr. Mohammed Land Council submits that the appointment of the respondent number 3 not only adheres the rule, not only adheres the rule, adheres the law, in as much as there is no proper selection undertaken by the state respondents, and the appointment of the respondent number 3 has been made merely on the government approval, on the purported government approval, which is not permissible under the law. The responsibility is not a landowner.
Lordship.
Therefore, he cannot be appointed to the post of chokidar, which is to be the post to be filled up by on the basis of landowner
Lordship.
list of. Therefore, the appointment the respondent number is liable to be set aside. Respondent is liable to be set aside at first, and the direction may be issued to the respondent for authorities to consider the case of the petitioner for appointment to the same post of chokidar by in accordance with the clause 3B, right?
Yes, Lordship.
Clause 3B of the notification dated 05/03/2018. Next one.
But I'm also relying on an authority with regard to
Hmm?
appointment without any advertisement, Lordship. Authority.
Which one?
2011, Volume 3, SCC. Page 436.
Then you write in support of his submission, Mr. Mohammed Lankar has relied the judgment of the Honorable Supreme Court in the case of State of Odisha versus Mamta Mahanti. It's all settled position reported in 2011, 3 SCC 436.
Paragraph 36.
Who? Para
36, Lordship.
to project that
Page 452.
36.
Yes, Lordship. 36. Page number 452.
To project that no person can be appointed even on temporary or ad hoc basis without inviting applications from all eligible candidates. Will not mention this.
Lordship.
What is the affidavit of respondent? What is your affidavit? Affidavit respondent number 3. Affidavit in reply. Yes. Per contra, MS so-and-so, United States Council. For the respondent number 1 and 2 submits them. The petitioner may have been the native of Nitong village under Jabuka range, and the Nitong village might have donated the land free of cost for establishment of Tijit Circle headquarters. There's no such oral or written agreement between the landowners and the government to provide any grateful post to the petitioner, particularly by the Soil and Conservation Department. She submits that Christoph, since there's no either oral or written or either written or oral agreement between the petitioner and the government, the petitioner is not entitled to avail the benefits as provided in the notification dated 05/03/2018, right? Christoph. She submits that the appointment of the petitioner, response number 3, has been made on the basis of the approval of the government. Approval of the government. What is that order? Approval of the government on the basis of the government approval letter dated 18/02/2020. Mr. Hauba, he fairly submits that there is no record as regards the selection process that might have been carried out, might have been undertaken by the state respondents. That is what I say. There is no record as regards the selection process. Christoph. Next para. Yes, what is your submission? Response number 3.
I have, having learned about the vacancy, I have applied.
Hmm.
And then on the basis of the government approval, I was appointed.
Mr. Swenso, learned counsel for the response number 3, submits that the response number 3 has applied for appointment as chokidar on the vacancy created due to demise of one Sri Yai A. Konyak. You'll get it in page 27. Was working at Chokidar under the establishment of Director of Soil and Water Conservation, Nagaland. List of the government and as per the thereafter on the approval of the government by letter dated 18/02/2020, the response number 3 has been appointed. Who on the basis that he is a resident of what do you call?
Indigenous independent of
indigenous inhabitants of district of Mon district.
and having found eligible to be considered.
Hmm?
And having found eligible for considered.
And after having found suitable and eligible and suitable for the said post. Mr. Therefore, there is no illegality in appointment of the respondent number 3. Mr. He submits that though the petitioner may be one of the landowners, however, there is no agreement, either written or oral, for providing employment in lieu of the land donated for government establishment as the requirement to avail the benefits of notification dated 05/03/2018 there must be either a written or oral agreement to oral agreement for providing employment to the landowners who have freely donated the land for government establishment. Therefore, he submits that the petitioner has no right to claim for appointment on a landowner basis. Next paragraph. I've considered the submissions of land council for the parties, and also there is the materials available on the court. Next paragraph. The state of Nagaland has framed a policy with regard to appointments to grade 4 posts and the government under the government of Nagaland on land ownership basis. List of a notification has been issued by the Chief Secretary, the government of Nagaland, by the 05/03/2018. List of 2018, which is reproduced herein under page 18. Next paragraph. Bare reading of the above notification shows that the landowners who have donated freely for establishment of administrative and block headquarters without compensation not without compensation, come on. Where there is where a specific written agreement exists providing for employment to the landowner, the claim of the landowner for employment should be settled as per such agreement. List of, if there is any claim for providing employment as a result of oral agreement, the department would refer the matter to the Deputy Commissioner of the district concerned, who shall examine such claim, including as to whether any employment or any other facilities, including country or supply order, has been given in the past by obtaining written statements from all the stakeholders, and thereafter the recommendation of the Deputy Commissioner be referred to the be referred to the Department of Land Revenue for advice in such cases by the department concerned. Next paragraph. It is admitted position that the petitioner is one of the landowners for establishment of established landowners of Tijit town, Mon district, and the land on which the office of the SDO, soil and other conservation, Tijit is established. This stuff. The petitioner has applied for allotment on landowner basis in terms of the notification dated 05/03/2018. In the year 2020, you have
19,
applied
Lordship.
2019,
2019.
particularly on the vacancy caused due to the death of earlier incumbent, claiming that he is one of the landowner, and the post which has fallen vacant be filled up on landowner basis in terms of the notification dated 05/03/2018. Mr. Perusal of the documents. And no, record doesn't reveal. No. There is no record to show that the petitioner has entered into a written agreement providing for appointment to grade post on the basis of land ownership as is required under the notification, under the said notification. However, on oath, the petitioner has made a statement that there was an oral agreement to that effect, which could be seen to be fortified by the certificates issued by the chief Ang of Yang Chief, what is that?
Jacoba Range.
Huh?
Jacoba Range.
Chief Ang of Yang of Jaboka Range. No, Chief Ang of Yang I think within bracket Jaboka Range. Within bracket of Jaboka Range. Tijit, huh? And the additional deputy commissioner Tijit. Come on. Since there's no dispute as regards the petitioner being the landowner for government establishment. Come on. I'm of the view that the respondent authorities are bound to consider the case of the petitioner in terms of the notification dated 05/03/2018 and for providing employment on the basis of land ownership, as the petitioner having been donated the land free of cost. Please stop. Next paragraph. A regard being had to the appointment of the respondent number 3. Come on. Is fairly submitted by the learned State Council. There's nothing on record to show that a semblance of selection process has been undertaken by the state respondents before and for appointment to the said post of Chokidar under the establishment of Directorate of Soil and Water Conservation. This stuff. It only indicates the government's purported government's approval, letter dated 18/02/2020. This stuff. It is Christopher. Law is well settled. That no person can be appointed even on temporary or ad hoc basis without inviting applications from all eligible candidates. If any appointment is made by merely inviting names from, no, will not say. If any appointment is made without inviting any applications for open competition, providing opportunity to all the eligible candidates, same would infringe the fundamental infringe Article 14 and 16 of the Constitution. As it deprives the candidates who are eligible to participate in the selection process and from being considered. For a valid and legal appointment, mandatory compliance with the constitutional scheme of public employment is required, or else same would violate Article 16, which requires that every such appointment be made by an open advertisement as to enable all the eligible persons to compete on merit. Having considered that the petitioner, the appointment of the respondent appears to have not been made under any policy or scheme of the state, and without there being any selection process for filling up of the said post, except on the mere government approval, I'm of the considered view that such a course of action would not be permissible under the law, as it would infringe Article 14 and 16 of the Article 14 read with 16 of the Constitution. List of. Therefore, the appointment of the respondent number 3 is not sustainable. List of. Next paragraph. for the in view of what has been discussed here in above, and also here in above, above the considered view that the the petitioner is entitled to be considered for providing employment in terms of the notification that is 0503/2018 as the petitioner is one of the landowners for establishment of office of the SDO, Soil and Conservation
Lordship.
Department, Government of Nagaland. List of the list of the respondent authorities, accordingly are directed to consider the case of the petitioner for appointment to Great Port post accordingly. In terms of the notification dated 0503/2018, list of the consideration directed here in above is no, please it is made clear that the consideration of the petitioner would be subject to the availability of the post earmarked for land, earmarked for appointment on a land ownership basis in terms of the policy of the state.
May I make a submission, Lordship?
List of
The present post, Lordship, it arose after 25 years after
No.
the land was donated, Lordship. For the
See,
first time, Lordship,
you cannot be appointed on all the posts.
Lordship, only against this post, the present post which was.
See, I said it's a reverse. There should be reverse discrimination.
Lordship, otherwise I have to.
Suppose
wait
you are
for 25 years,
the
Lordship.
you are the class of persons.
Lordship.
You are not all. What about the others? You have the state
Lordship,
can
I
have,
agree.
yeah,
Lordship, I agree.
state can they can have a policy
Lordship.
for a class of persons,
Lordship.
which they have done. But
Otherwise,
you
the
cannot.
policy- Lordship.
What about the other class,
Lordship.
right?
Yes, Lordship, I agree. Lordship.
Therefore, even the policy has to be implemented.
Lordship.
There must be some. I mean, the procedure has to be there.
Lordship.
All the posts cannot be for land alone. I mean, land ownership.
I agree, Lordship. I agree.
They must be open. I mean, the general post where the other people can also participate.
Yes, Lordship. Just on one facet, Lordship.
Yes.
The establishment is a very small establishment, Lordship, and there are very limited grade 4 vacancies there, Lordship. Now it arose for the first time in the year 2019, Lordship. It was up to 25 years, Lordship.
Then that's why if they want to implement, they may appoint you. I mean, they consider you in this post. We cannot tell them they appoint you considered in this post.
Lordship.
There must be. They have to earmark it.
Yes, Lordship. Lordship. Great, Lordship.
Having the appointment. No, the appointment order of respondent number the order dated 7 so and so is also hereby set aside in view of the fact that the respondent number 3 has not been appointed by following the due process of selection. However, the respondent authorities are directed to fill up the said post of Chowkidar by following the due process of selection, including including open advertisement, so as to enable by providing all the eligible candidates to participate in the selection process. That's all. Because your appointment is neither under any policy, is not it? You can participate also.
Much obliged.
Neither he is not there. Red petition stands disposed of accordingly, no order is to cost.
May I please, my lord?
You take
Lordship.
this, you give it to him. Just print out. Online, this is online, you just print.
With sincere apology, Your Lordship, I beg my Lordship indulgence in item number 7. The council representative state respondent is already here, Your Lordship, so she'll be assisting this court in disposing of the matter, Your Lordship.
Yes.
I'm
You are
returning back
there.
the second copy.
Who is there?
Lordship.
You are there.
Lord.
Okay. Yes.
For hearing, item number 10.
Yes.
Lordship, this is an first appeal from the order of the District Judge Mokchung, by which the suit was dismissed, was rejected, the plaint was rejected at the threshold under Order 7-11.
Yes.
There were two applications filed by the defendants, one by the
Ready?
defendant number.
Are you ready?
Lordship, I'm referring for respondent number 3, 4, and 6.
3, 6, and 7.
3, 6, and 7.
What about others?
But additional AG
So two applications, madam, was filed under Order 7-11. One was by defendant number 3, 6, and 7, and the other by defendant number 1, 2, 4, and 5. And these petitions were heard together, these applications were heard together, and my suit was dismissed on the ground that I have no cause of action, and also it is barred by law, mainly the law of limitation. Lordship is well aware that while deciding an application under Order 7-11, the only thing that the court must look into is the plaint, averments made in the plaint. And purportedly, the learned court below says that from the plaint, it discloses that I have no cause of action and also I'm barred by law. I'll take your Lordship to the relevant portion, operative portion first. Page 500.
512.
500.
Start from 512.
Yes. Yes. My Lord, may kindly come to 519. 519. May I read from paragraph 20 onwards. Upon hearing the learned counsel for both the applicants, defendants, and the respondents plaintiff, and on perusal of the plaint, this order is being passed as follows. The averments made in the plaint in the annexure file along with the plaint on the face discloses that acquisition of land in caution has been acquired as per procedure prescribed under the Act of 1965. Therefore, filing the suit before this court is barred by law under Section 17 of the Act of 1965. Section 17 of the Act 1965, the Nagaland Land Requisition and Acquisition Act 1965 are reproduced here below. Section 17. Save as otherwise expressly provided in this Act, no decision or order made in exercise of any power conferred by or under this Act shall called in question in any court. The second prayer for the degree of compensation as per provision of right to fair compensation and transparency in Law Acquisition, Rehabilitation and Settlement Act 2013 to the plaintiff. It is observed that the Act is not applicable in Nagaland, and as Nagaland State Legislative Assembly has not been adopted by a resolution as envisaged under Article 371A. of the Constitution of India. Thereby, this court has no jurisdiction to entertain any suit under the said Act of 2013. The arguments made in the plaint on their face discloses no cause of action. The plaintiffs have failed to establish a legally sustainable cause of action to seek the relief as prayed for in the plaint. The suit, as it appears from the statement in the plaint, is barred by law of limitation as well. Though the plea of limitation is always a mixed question of law and facts, in the instant case, the entire perusal of the plain amendment itself clearly shows the suit itself is barred by limitation. This court is of the view that it is a fit case which falls within the ambit of Order 7, Rule 11B of the CPC. Therefore, in view of the above reasons, the plain stands rejected in terms of Order 7, Rule 17, 12, and Rule 11 of the Civil Procedure Code. So, my lord.
Number one, it is barred by
Section 7.
Section 7.
Section 17.
Number two, the suit for compensation under 2013 and the 2013 having is not applicable in state of Nagaland.
Yes.
It cannot be.
It cannot. And
the court has no jurisdiction.
No jurisdiction. And secondly,
see, there is a judgment by this court.
This court. I'll come to that. Earlier, when the suit was filed, there was a judgment by Devashish. Justice Devashish Board was saying that 2013 is applicable. That was in the earlier part of 2022, March. Then in 2024, this
court has said
that it is not applicable because of 371A. The suit was filed in between. But my lord, I'm saying my case is in the prayer, this prayer was made. If I'm entitled to compensation, it doesn't matter whether this act is applicable.
Just for clarification, that I've taken Justice Borua's judgment is it doesn't talk about the applicability. It was just a presumption that this is applied.
Yes.
The issue was not raised. That I have considered in my judgment. Because the issue was whether it is applicable or not. But I had an occasion this court has an occasion to consider whether this 2013 is applicable or not.
Yeah, that is.
Is it under appeal? But then.
Yes.
It's under appeal.
Absolutely correct. Lordship is absolutely correct. But my case is the suit cannot be.
So that way you cannot say that the coordinate bunch has two different views. It's not there two different views. Because that was Justice Barua has not considered whether it is applicable or not. It was nobody raised that issue. I think that I have.
Justice Barua in one of the paragraphs says that all acquisitions under 65 will be also to the 2013 also.
It's been there. There's an observation and it has been held there. But it was whether it is applicable or not, it was not the issue was not discussed.
I'm not on that. The suit cannot be rejected just because 2013 Act is not applicable.
Yes.
Because there's another acquisition act. If I'm entitled to compensation, just because I've referred that doesn't mean that my suit can be rejected. Because Order 7 Rule 11 doesn't say quoting a wrong law will be liable, the suit will be liable to be rejected because it's already given one other grounds. So if 2013 law is not applicable, even that, if 65 is applicable, the relief can be given to me under 65.
What is the suit about?
It's about occupation of land without paying land compensation. And the entire matter is disputed. The dispute is, I'm saying in 1960s, in the 60s, the armed forces came and occupied this land. Insurgency, a lot of height of insurgency. Army used to come and just occupy the land, and that's how it was occupied.
So they said that this has been acquired under the.
That's absolutely wrong. This is disputed.
Okay.
And when is disputed?
No, according to them, they said that the land has been acquired under this Requisition Act, Nagaland Requisition Act.
That is wrong. I can show it, my lord. Absolutely wrong. And not only that.
There is 10.
Yes.
Or court has taken from there only.
My lord.
Why they said that this is barred under the Section 17?
Yes, my lord, may kindly see. They brought a notification.
No, you said that the fact discloses that the acquisition of the land in question has been acquired as per the procedure prescribed.
I'm saying this judgment is erroneous. This judgment is erroneous. This order is erroneous, my lord.
Why this is before this court?
First appeal.
No, that's why. Why not court number 2?
Court number 2 cannot take up the matter because she's from this village.
Huh?
Village.
Okay. Achha. She has recused.
There's already an order.
Huh?
There's already an order first.
She is
She's
from
recused.
that village.
Yes.
Okay. Take.
Shall we proceed, my lord?
Yes, yes, proceed.
My lord, my case is this. Accusation. If there's accusation, it has to be done strictly in terms of the procedure prescribed. Otherwise, it's not accusation. Nonsense. They say, my lord, even the defendants, they are not very sure. When they file the application, defendant number 1, 2, and 1, 2, 4, and 5, which is the state and the deputy commissioner, said it is purchased. The land was purchased. And defendant number 3, 6, and 7, which is the police, which is occupying the land, says it's accusation. My lord, there's a difference between purchase. Purchase is always mutually agreed. Accusation is compulsory in nature. Even the defendant don't know. Both the defendants here, one says purchase, one says accusation. But let it be, my lord. If there's a disputed question of facts involved, canvas would be rejected at the threshold, which the lawyers would clearly settle. Now, we have to see only the arguments made in the plain. And whatever they file, whether they file the WS or the application for rejection, that cannot be gone into at all. Now, thus the finding, that conclusion arrived by the single judge, the court below. Can that conclusion be arrived by reading my plain only? Therefore, my lord, this honorable court has to take the trouble of reading the entire plain alone. 21, page 21. Hello, may I start from page 31?
Page 31.
Yes, sir. I'll just read the relevant portions only. Page 31. Page 31, married from paragraph 3 onwards. The plaintiffs are having common grievances and the same cause of action against the same defendants in as much as the defendants are in forceful occupation of vast land of local village, as fully described in the schedule appended here below, without making payment of land compensation to the plaintiff. This itself is cause of action. Also, the defendants are legally interfering into the village land, obstructing the plaintiff, even from cultivation and other development in the plaintiff's own land, wherein plaintiffs, to avoid any untoward incidents, being law-abiding citizens, are filing suit jointly against the defendants. Then, my lord, be it respectfully stated that the plaintiffs have authorized such and such. My lord, this plaintiff number 8 is 86 years old. May I just pause here for a moment, my lord? 86 years old. He's also a junior engineer, retired as a junior engineer. He's a literate. I'll show why I'm placing this at this moment. That represents all the plaintiff and for swearing and on affidavit, signed documents before the Honorable Court, etc., in respect of the present suit. 4. The defendants herein are the state of Nagaland and its machineries responsible officer of the state in Nagaland, who are interfering with the plaintiff's land and illegally enjoying traditional village land without acquisition and also even without accessing norms of acquisition procedure as provided under the Acquisition Act, with issues of notice pertaining to claims and objection, notification, etc. So also without making payment of due compensation as per provision of law. Then my lord, may kindly come to 6. Paragraph 6. The plaintiffs were born and their upbringing is from Longkung village, district Mokshu, Nagaland, and he inherited the land in Longkung village from their ancestors, who established the village and had been enjoying the village land since time immemorial, practicing village tradition of joint cultivation in the village land as per customary practices and uses of Longkung village, till the village was forcefully occupied by armed forces personnel without any acquisition or making payment of land compensation to the plaintiff, and subsequently the armed force personnel, while parting, instead of handing over the land to the plaintiff, rather arbitrarily handed over to the plaintiff land to the defendant number 7, that is the policeman. Then paragraph 7.1. That it was way back in the 60s while the locality was facing disturbances from armed forces personnel under the Armed Forces Special Powers Act. Through means of duress, threat, and force, said personnel chased away the predecessors of the plaintiff from their own land on gunpoint and entered into forceful occupation of the same, suppressing the voice and objection of the villagers, including the predecessors of the plaintiff. Subsequently, while partying, the armed forces personnel allowed the Nagaland police to enter into possession of land by siding away the forest to the then village leaders, that is the predecessors of the plaintiff. 8 months. The alleged sector of Lungkum village, that is the village of the plaintiff, a vast area of land are presently under the occupation of 2nd Nagaland Police Battalion, who have been enjoying the village and land arbitrarily, illegally, without paying land compensation. They are to deprive the plaintiff from their bona fide entitlement as per the law of land. 9 months, 10 months. That's since paragraph 10. That's since this paragraph 9 also, I'm sorry. The plaintiff stated that on 15/11/1969, the landowners of Lungkum village, Alesian sector, held an emergency meeting and unanimously resolved 4 resolutions such as to form a union, demand for compensation in respect of damage of plantation and not for selling the land. That since inception, the plaintiff through their predecessors, 10 months, have been approaching and urging upon the defendant, that is the competent authorities of Nagaland Police Department and also the government, besides other government machineries through the Deputy Commissioner Mokshan Nagaland Force, resolving the issue of payment of land compensation pertaining to forceful arbitrary occupation of the village land by armed forces personnel and thereafter by Nagaland Police. However, the authorities have done the deaf ear in matter in issue till date. My Lord, may kindly come to 12 now, paragraph 12. Paragraph 12, that on several occasions, the plaintiff approached the defendants for providing the land compensation against land occupied by government through its police battalion, but the plaintiffs were apprised that the land compensation in respect of land under occupation of 2nd Nagaland NAB battalion in Alesian sector of Lungkum village were purportedly paid to the landowners. 13. That on further approach, the plaintiff were apprised that the land in Alesian sector of Lungkum village wherein present 2nd enemy battalion station were acquired by the defendant by way of purchase. However, on repeated approach, the plaintiffs were not provided with copies of sale agreement in respect of the plaintiff's land. Rather, the plaintiffs were informed that such documents were not available. 14. That on recent date, when the RTI applications was filed before PIO, Office of the Deputy Commissioner Mokshan, for providing land acquisition documents and for also selling, if any, in respect of the alleged sale of the land under occupation of 2nd enemy battalion in Lungkum village, the Concerned Public Information Officer provided some purported sale agreements stated to have been executed between the Deputy Commissioner Mokshan and the vendor's village during the year 1974. That at bare perusal of the said documents furnished by PRO, it is observed that the purported sale is drawn in white paper without having any signature of the parties in the first page of such purported sale agreement. More surprisingly, the boundaries of the alleged plots were shown against that number of land. Furthermore, the signature of the vendors in the second page of the purported sale list also do not match with the original signature of the villages purported vendors. 16. That the plaintiff do not dispute the payment of compensation against damaged plantation crops, madam. This we admit that. However, the stand of the government authorities pertaining to the release of compensation of village land presently under occupation.
What you are admitting?
I'm admitting that the plantation's crops were damaged.
For that,
in that area.
For that,
I have received.
you have received the compensation.
That I'm admitting, but not the land, not for the land.
Is there land? Is there dispute regarding the ownership of the title of the land?
Title of the land? No, my lord. They said it belongs to us.
Yes. Then what's there?
No.
The issue is
now payment of compensation.
Payment of compensation.
Give me back my land.
Huh?
Give me back my land. Or pay me compensation. They are occupying the place.
Then why shoot?
My lord, what was happened? They disputed. They have furnished us. They have furnished us with certain documents claiming that the land was acquired or the land was purchased. One says purchased, another says acquired. So now, if we come to the real court, because usually we have to come to the real court for acquisition, say acquire the land or pay compensation. But now, since the facts are disputed, we will file a suit to establish the fact that no, this has not been acquired, that no compensation land compensation has been paid. This is the entire case. Now the suit is rejected. Disputed questions. How can the suit be rejected without even trial?
They are saying that this has been acquired. Acquired under.
So whether we are disputing it.
Under this in Requisition Act, Nagaland Requisition Act.
One of the defendants is saying this under the 65.
Huh.
police.
Huh.
The state, the deputy commissioner says purchase, my lord. Look at that, sir.
Huh.
Two different views. How can there be two different views? Which is totally.
But in any case, it has been alienated.
No, that's I'm saying. No, my lord, it's not been. Though that place.
One is saying that it has been purchased.
One is saying.
Other one is that we're doing
I'm
requisition has
denying
been
both.
acquired.
I'm denying both, man.
Okay.
I'm disputing both. And if your lordship looks at the documents based on which these claims were made, because I got these papers only in the year 2022 through when I filed RTI application.
When it was required, according to
74, that's what they're saying.
74.
74. Now, my lord, acquisition.
That's why they said that it is barred by limitation.
My lord, law is set when it comes to deprivation of property. No, the pleadings. The state cannot take the plea of adverse possession. State cannot take the plea of limitation. Settled law. Delay latches cannot be a ground to deprive a property. Property is not just a constitutional right; it's a human right now. Now, can it
See, perhaps I find it since the title and ownership is not disputed, right?
Yeah.
Dispute is whether it has been purchased
or
acquired.
Dispute is that. Dispute is that. Now, if I come to this high court directly under the ring, that dispute is made. I'll have to go to the trial court. So therefore, to establish that it has not been acquired, it has not been purchased.
The state cannot have two different
different views at all, my lord. And the notification itself, my lord. Mechanism, my lord, acquisition.
I think, Writ court could have been to place.
My lord.
Writ court may have a jurisdiction. Writ.
Yeah, but my lord.
Because if it's the dispute is only between the two the respondents.
Yes.
Amongst the respondents. They have to clarify. That's all.
No.
Whether it is acquired or it is not purchased.
No.
So what you are saying is that it's been neither purchased nor acquired. That is you are saying.
Nothing. So now
that will be a matter of record.
That will be a matter of record, but the record they're showing.
We can at least go into, because it's a issue is whether this is the acquisition only, right? Purchase or acquisition.
Lordship,
I don't know. It may be too far. I mean, you have gone too far now.
For me,
we cannot say that you file a writ petition, right?
Yes.
We may not.
It's petition is easier, faster. But I've taken the longer route, the harder route, because in the future again this.
So why you are traveling your client?
Not me, no. That's not me.
No, on a lighter note, taking to the longer road.
Oh,
everybody wants a shortcut.
Lordship, those were not the situation, my lord. The consideration was if we come to the High Court again, then the facts itself is disputed. One party is saying this, the other party is saying
I'm
saying this.
If the respondents, the government state respondents, have a take a different stand, we'll go by what is as per the record. Simply saying that one deputy governor saying that this has been purchased, police department they say this, we'll go by the record. What is there in the record?
And one more thing, man.
What is there in the record?
I should. They have given
not they are saying, not just making their statements.
One notification. One notification was published in the Nagaland Gazette on 15 May 2024. A notification dated 18 April 1974, which was published in the Nagaland Gazette on 15 May 1974, which says the land is purchased. The land is purchased from this person under the Act, Acquisition Act of 1965. And if any person has objection, come to the Deputy Commissioner before this date. Is that acquisition, my lord? Is that the procedure for acquisition? The procedure is prescribed by law. I'm also disputing this. I was never aware of this notification.
See, if this is the thing, I don't know where is the bar under the jurisdiction.
No, my lord. This lordship is like this.
I'm
appearing for the first time in this case.
There was a case.
Yeah.
I mean, of Himachal Pradesh.
Actually, my lord, but I'll be needing. I have to leave in this because of my legs.
No issue. Santi or something like that.
All right.
The land was acquired by the PWD. in 1960.
Oh,
There was a writ petition filed.
all right.
The government raised an issue of delay. And Supreme Court said it's view of the, the Article 300A. Delay should not, defeat the justice. So what I could, privacy could gather is that suit may not be the grounds on which your plaint has been rejected may not be
Yes,
I mean,
ground for rejection.
ground for rejection, but then the entire matter
Lordship,
to this privacy view of this court is
hmm,
can be
adjudicated
under 226. It's a matter of acquisition only. Suppose there was a if notification issued in violation of the provisions of law. Obviously, the writ court can enter into those arenas also.
but now this
It's a matter of your right to property.
true.
Under Article 300A.
Absolutely no.
So suit may not be.
Suit may not be.
the-
I'm sorry, Mama, but I'm appearing for the first time in this case. In this
So
case,
let us do one thing. Will not take up today because I may have a different reason to dismiss your, reject your plaint. I may not agree with this, impute order, the grounds.
because
But obviously, I may privacy view that suit may not be maintainable.
great is mentioned. The Lordship was-
Suit may not be maintainable. Think over it.
But-
We'll take over that some other day.
If that is the case, my lord, the Lordship will be dismissing this petition on the ground that writ may be maintainable.
Will not say will go. I have seen your plaint. I'll not say so.
Then
I cannot say that.
yes.
This is I'm just echoing my view. So far as this first appeal is concerned, I have some reservation on the grounds which your plaint has been rejected. But then there is a ground for me, privacy, this court can be rejected your plaint on some other ground.
Lordship,
May not be the proper approach,
Lordship,
but I will give a reason why your suit may not be maintainable.
as long as this order is there, unless the process.
Obviously, will interfere, but not on the ground, but then ultimately your suit will be rejected.
Remedy
But
is
of course, I'm sitting on past appeal.
yes, Lordship's opinion is the remedy is not a suit, but it's assessment. What should I be thinking about?
You think about
Yeah,
it.
let me
It's
think
better.
about it.
Nice, sir. Think about it.
Give me some time about to discuss it with my clients also.
Yes.
But as long as this order is there, my lord,
Yes, of course. This will.
this order comes to me.
So we'll adjourn the matter. You think about it. Anyway, I'm curious to know what is the stand of why you have two different stand.
Worship, I just want to my grandfather was killed. The date of my father was, someone says, shot dead. Another say, step, me killed by a knife. 4 years back. And if I file FIR now on 2026, will there be any other law to stop me to file FIR?
Then so far as this case is concerned.
No, so far as this case is concerned. Now, my grandfather was killed by someone, and I filed FIR only now, after 30 years or 40 years. Then the law will say, no, there is a law. It's already late. But killing of my grandfather, I'm still feeling that the bereavement still there. So in the present case, there is all documents are there by the state, received by the landowner, and the grandchildren of the landowner now they are coming to the court. Their land was not purchased.
Anyway.
Not acquired. So that's the case here.
You are saying that there is a delay. This is barred by limitation.
The delay is there. So whether it's acquired.
See,
or
this court
purchased or not,
doesn't
make
believe.
any difference.
This court doesn't believe in technicalities. We first will have to look for the substantial justice.
Lordship,
And law is well settled on that.
Lordship,
And so far as the acquisition and requisition of the land is concerned,
yes.
there is a Supreme Court judgment. Delay will not. Delay cannot be a ground to defeat the justice. As I have just pointed out. You read, have you come across
Yeah, and now
by Justice Banerjee?
the order dated 19 January that the impugnator,
That was acquired in 1960.
70s.
No, 1960 in
Yeah,
that
yeah.
case.
But
Himachal case, it was
Yes,
acquired in
yes.
1960.
Yes.
Huh? Vidya Devi, huh?
Yes.
Something Santi or
Refer that
Vidya Devi.
Impugn judgment is 2024.
Hmm.
So order was passed under Order 7 Rule 11. So there are 4 or 5 conditions are there.
Ah.
When the cause of action will not be disclosed by the plaintiff, then that's also another part. And clause D,
That should have been ground to reject the plan.
Yes.
But that is not a ground for rejection of the plan. That is what he's saying.
no. But it
They have
is-
rejected the plan on the ground of jurisdiction, on the limitation.
Yes.
Right.
No, limitation.
The limitation as rightly held, it's a
Yes.
question,
And
a
that's
mixed question of law and fact.
There's no
There it can be always taken care of at the time of trial.
But
Right.
yes, there is no limitation.
So the grounds of rejection is of the plaintiff under Order 7 is one is barred by Section 17 and the 2013 the Act is not applicable. That cannot be a ground under Section 7. I mean Order 7.
But whatever it is a
Facts, forget about the facts. Why
It
don't
is a petitioner,
first the facts?
they are the person, so they have to disclose the cause of action.
CPC, Civil Procedure Code.
Anyway,
Read. Let us, refresh ourselves. Order 7,
Rule 11.
Rule 11.
Yes. Four conditions are given there. Rejection of blame.
So D, most probably they have been booked.
D.
D.
Yeah.
Barred by law.
And also, barred by law is when it comes to limitation by law, limitation is question of law and facts.
The barred by law, they said that under Section 70 of the requisition
Because acquisition has taken
is barred
place. Acquisition has taken place. So whether acquisition has taken place or not, that has to be.
that is the dispute. This is the dispute you are
That's a
discussing.
dispute. That's a dispute.
Hmm.
That itself is a dispute.
Hmm.
The Supreme Court also is very clear. Disputed question, the suit cannot be rejected under this.
Yeah. Rightly, she has mentioned, he had mentioned also.
Yes.
Trial court has mentioned
All
it.
of this mentioned, but she has thoroughly come to a wrong conclusion. And cause of action, my lord. Cause of action also she has mentioned. But when I'm saying, my lord, compensation has not been paid. That itself is a cause of action.
I'll not make you wise. We'll adjourn the matter. Think over, we'll keep it pending. There's nothing much to be heard. We'll have to hear you and yes.
Just one.
Why you should be deprived? Since we have heard both of you, definitely you will be given an opportunity.
Page 339.
Huh?
Page 339.
339.
These are their own documents. Type copy is there, 340.
340.
340 is a type copy. This is how the compensation was assessed. Lordship has got it. This is proceeding under section 11 of 1 of 1890. There is a typing mistake, Your Lordship. If Your Lordship may kindly come to page 339, though it is not illegible, it can be made out proceeding under section, it should be 1894. Lordship has got it.
Hmm.
Now, this is how the compensation was assessed. This is the compensation was assessed under Section 11 of the Act of 1994.
This is in which year?
This will be that time only 1974.
1974.
For construction of second NAP water at Alijan. This is the suit line in question. May I take your lordship next to page 352? All this relates to assessment of compensation. Page 52, 352. The case petitioner says that only the damages were compensated, damages caused to the standing trees, crops, but then your lordship may kindly come to column 3. Additional compensation for the market value under section this.
Page
352.
352.
All these documents relates to compensation paid to different landowners, your lordship. Lordship of 352, column 3 and 4.
Who are these people? Are these are the plaintiffs?
These are plaintiffs documents.
These are the plaintiffs? No. These persons.
Yes.
Yes.
Except one is alive. All these people are there.
This one?
Yes.
No, what I'm saying is these are the...
For the land.
No, these are the plaintiffs.
No, one.
They are not.
They're not a plaintiff. There's one person who's alive, who was there. He has declared, and very apparent from the signature itself, the person who I was saying that he was a junior engineer. He said, "This is not my signature. I've never received this." And look at the signatures also, my lord. May I kindly see for a moment? Show me.
This was done in 1974.
Okay. Since you are not disposing of the matter,
I can answer clearly, my lord.
Yes. But think about it. Otherwise, I could have finished it. Though it may be voluminous. Yes, hard Mr. Empty London Council for the appellant, and also hard Mr. Empty himself, London
1, 2, 4,
Additional Advocate General for 1, 2,
4, and 5.
4 and 5. Respond.
TB
Jamil.
for 3, 6, and 7.
What is your view?
Lordship.
Neither the suit lies nor the writ will lie. What is your view? I mean, you are not for a time being. You say we're asking the opinion as an independent, not as a party before.
No, your lordship. If what they are saying is correct, that it has been illegally occupied without paying any compensation. Yes, then they can read code can be correct. 308. You cannot, state cannot deprive a person of this property. But this is a case where compensation has been assessed as per the Act of 1894, Relocation Act.
So, according to the, in any case, suit doesn't lie.
Suit doesn't lie because bar is there under
Section 17.
Section 17, your lordship.
Is it the documents which you have shown is under 1894?
1894.
Not under requisition. So, what's the question question of Section 17?
That is Acquisition Act. That is Acquisition Act, your lordship. And now,
no, that's what I'm saying. When your land is acquired under 1894, where is the question of the 65 Act coming into?
No, that is the State Act.
See, even if you have a state act, once the act, the land is acquired under a particular law, why you bring it to the state act? It's not even there. It's not a case of acquisition under 65.
Yes, at that point in time, 1894 was applicable. Assessment was done as per 1894.
Yes, that was 74.
Then, no, 1965 Act also provides that so far as Section 11 is concerned, the Act of 1894 will apply.
No, under which law the land was acquired? Only you're showing it's 1894.
No, 1965 Act. But then assessment was done because 1985 Section 11 says that assessment can be done as per 1894. That is the Central Act.
So, but then, is it been acquired under 65 Act?
Under 65 Act, maybe the gazette, whatever, but then it has been done accord as per this, the Acquisition Act, Your Worship.
1894. 1894.
1894, the gazette is said, Your Worship.
LA Act 1894. You have shown that it's under section 11.
That assessment of compensation. What I've shown is compensation, assessment of compensation.
You show us there whether the land was acquired under 65 requisition. Is it so?
Now the land acquisition Act 1965, that's a creation of 1894. It's a creation of 1984.
Oh, therefore, whether the land was acquired under the 64 or 1894.
No, that 1965 A is derived from the 1894 acquisition.
But then,
Yes.
under which act, 1965 or 1894 land was acquired,
No, no,
according to you?
1965, it will count if it-
No, it's not a no question of coming or invoking automatically. Some documents he has shown is 1894.
Yeah, 1894, earlier, during the Nakahira's time, 1894 was in the.
Lordship, may kindly come to page 431.
Just read
The
it.
gazette notification.
Saying what?
Now here, this notification made under provision of section 9 of the Nagaland Acquisition and Acquisition Act of 1965.
That is what?
This
This is what? In respect of this
is a
present land?
Yes, this is a gazette notification.
No, it's a respect of present land.
Yes. This is the gazette notification. Your Lordship may come to page 431.
431.
This gazette notification was not annexed in the plane, which I annexed in my IA.
431.
431.
431.
May I read out, Your Lordship?
431, 431. Yes, what is this?
This is the
Government
government
of
of
Nagaland. It's
Nagaland Gazette, May 15,
land within the
1964. This for construction of second NAP. And after that, Your Lordship, two paragraphs from above, this notification made under provision of section 9 of the Nagaland Acquisition Act 9. And once it is notified in the Gazette, Your Lordship, these are public documents.
1974. And what is that other documents which you have shown?
1894, Your Lordship, 339.
339.
339.
So according to you, the land was under the land Nagaland Acquisition and Requisition, but then the
Compensation,
what do we call?
assessment of compensation was done as per section 11 of the Land Acquisition Act 1894.
This is what you are trying to say.
I got the Nagaland Land Acquisition Act, but since Your Lordship is not taking out the
Yes, okay. Yes. Okay, I just wanted to
Otherwise, I
know.
can answer all this.
Facts, yes. Impingson and then sense, huh? You've taken? Next paragraph. After hearing the learned counsel for the parties at some length, it is
Yes, my lord, democracy.
yeah.
Just let us answer to get certain instruction in this one.
It is seen that certain instruction is to be required in terms as the matter pertains to. No, we'll not say anything. It's a first appeal. We cannot do it. We complicate the thing. Huh? Do you say no? On the party, on the prayer of learned counsel for the parties, and as agreed to by, let this matter be listed
3 weeks more
after 3 weeks. Think about it.
Yes.
Item number 11.
Yes, item 11.
Please, Your Lordship.
Yes.
Lordship, I am appearing on behalf of the counsel for a petitioner.
Hmm.
Since his medical treatment.
Lordship, yesterday I had a call from the principal counsel. I was told that he's going under medical treatment, had an accident, and then he needs to attend to immediate medical attention.
Which port? Your port?
Private respondent number
How,
6.
how you are appointed? How you are appointed?
There was an available vacancy post, so.
So you file an application and
Application.
then you have been
As
appointed.
well as the petitioner also had applied the same application.
Any process? What is the process undertaken?
No, thereafter, government approval was sent. That's how I was appointed.
On what basis? You are appointed on any landowner basis or something?
That's not.
Simple. Simply.
Submitted an application, they verified.
That cannot be permitted.
In fact,
You are depriving thousands of the eligible candidates.
no, but Lordship, here the petitioner himself is not the actual landowner, and I have also raised serious issues on maintainability, local standard.
Saying what?
Because the petitioner does not have the right to file this present petition. It's a frivolous writ petition. He is not the actual claimant. In fact, the representation which is at annex number 5 is submitted by another person who is Chipasao, the actual absolute landowner who donated the same land. In fact, after yes, Lordship.
Chipasao Mule,
Yes, Your Lordship.
landowner of so and so. Who is this petitioner?
The petitioner is in Vietnam. It is not a signatory in the agreement itself, Lordship.
Where is the agreement? Is there any agreement?
Yes, Lordship.
Where
The
is it?
petitioner have already annexed it, annexed number
Where is it?
2, page 14. The type of is 14A.
Page 14.
Yes, Your Lordship. Page 14A, type copy is at 14A.
An agreement logic. What is this?
Now in the bottom line, extreme right hand side, first Chipasao Muli, Institute Lota.
Following points for
Lota.
paper.
So these are the
land which
signatories.
is now
In that
entirely
process.
could be undersigned. So shall offer to the government of Nagaland as free of cost. Hence no land council would become claim on the condition that it will.
The Lordship, at annexure number 5, that is page 20, the representation submitted. The name is reflected as Chipasao Muli. It is not.
This is also a. How can this is be the agreement? It's not an agreement. It's a letter by the Shiposha Muli
Yes.
and
it's
three others.
correct, Lordship.
It's in 1976. How these three are they not related to? They are not the Pope. Parents of the petitioner.
No,
They are not connected.
not at all.
Lotha, Muli. Yes.
Lordship has rightly pointed it out. This is not an agreement. This is a letter to the Director Health and Family Welfare.
What he has said about this letter?
Yes.
This is annexer.
Page
Annexure
number
2.
20, annexure 5 series, Lordship.
No, what is statement he has made so far as annexure 2 is concerned?
The petitioner, Lordship.
Yes.
Okay.
Only had donated a plot of land for construction, primarily health and so worker. The subject to donated land on construction, the landowner had written a letter to the upon which had been duly certified then extra commissioner and had communicated the same to department by within the paragraph which is in to offering How he can claim what he's saying? Is there any connection between these landowners and the petitioner?
No, Lordship.
The landowner candidate duly recommended
It appears-
landowner in the present head government for. What is the
Otherwise, Lordship,
the
even
annexer one is what?
next year, what? This is a recommendation letter from the village council.
This is to the Siposho Mule, son of a resident of Sangor is a bona fide land of prime residence, and thus the Sangor station has no objection issuing discharge. What is this?
These are all manufactured.
Then is the bona fide landowner candidate for the post of service at the primary residence in Sangor, which is lying vacant due to resignation of Sri Bonatung Sen. That's the deposit. Landowner PHC and has no objection to issuing certificate. Okay, how he's come into picture?
That is why, Lordship, even in the annexure number 5, that is page number 20, this representation was submitted by Chipasal, not the present writ petitioner. So how can the writ petitioner claim that I am the actual landowner and seek for such?
What is the stand of the state? You are saying that although your appointment is not on the basis of your application or the approval with the government, but then he doesn't have the locus because he is not a landowner. Landowner is somebody else. That is what you are saying.
Yes, Lordship, the petitioner father is also not the signatory to the agreement, Lordship. The petitioner father is also not a signatory in the agreement, Lordship.
He's not there?
Signatory, Lordship. In the agreement.
He's not a landowner. Affidavit of what? Respondent numbers?
1 and 2, 1. 5, Lordship.
1, 2, 3, 4, and 5.
Lordship.
Yes, what do you stand? Due to the resignation of Sri Batung so medical was accepted by department against the said vacant post. 2 applications received by the from the petitioner. Application that it is apparent that he is the son of Semo Odo praying for appointment to so and so. Suppose the said application supported with NOC and signed issued to him by saying suppose only answer is somewhere name for appointment. In for that already appointed 9 persons.
Yes, Lordship, even the petitioner is against that.
His petitioners?
By affidavit, page 3, paragraph 5, Lordship.
Petitioners also been appointed.
No, Lordship.
So your stand is that he is not a landowner because neither the representation nor the agreement, right?
Lordship.
I mean that claimed at least purported agreement. His name is not there, right?
Lordship.
And on inquiry, you found that the already 9 candidates persons have already been appointed on landowner
Yes,
basis.
that was alleged by the petitioner. So in
No, see,
the petitioner is not eligible.
he only has annexed a list of 9 employees who were appointed on landownership basis. Therefore, on perusal, we said complaint and it is an admitted fact by the landlords that 9 so-and-so staff has already been appointed in the state so-and-so, that the state has framed the policy as well. So what you are trying to say is, the complaint of the one Muli, what is this? Siposhak Muli,
Lordship.
indicates that already 9 persons have already been appointed on landlords basis.
Lordship.
So it cannot be perpetuated again.
Lordship.
It cannot, no appointment can be made on perpetuity.
Lordship.
That is what you are saying. Apart from he doesn't have documents to show that he was a landowner. He is not a landowner. He is a landowner or what?
Petitioner is not a landowner, Lordship.
So where is your locus, madam?
Your Lordship, I'm not well conversant with the case. I was just instructed to appear on his behalf.
So that's why I've given you the file. Have you gone through? What is the case?
This is not the appointment of petitioner on the behalf on the basis of the Lordship.
But then you have not shown anything except that one certificate. All along in your statement, you have never said that you are the landowner. See, have you read the petition? Is a single so-and-so, the petitioner is central to, she said that is the landowner candidate duly recommended by landowner in the presence of head government for proposed of medical where the primary so-and-so is established. The head GB Sangro had also issued no observations to prove the same. You have obtained some certificate from the head Gabura to show that you are the landowner. But there is nothing on record to show that you are the landowner. Rather, it speaks something different. Then annexed 3, along with so-and-so, accordingly, Chief Medical on resignation of so-and-so being the candidate duly recommended landowner and the indigenous neighbor had approached the court for appointment. So both the applications were considered by the government, and your application and the application of the petitioner were considered.
That's how I was selected.
Both of your applications were considered,
Yes, Lord.
including his
Including the petitioner's
application.
Whereby that's Lordship. That's the reason why I wanted to show the inaction of the file.
Madam, very difficult. No case. What to do? Tomorrow. Where is he? He's around in the Kohima.
Lordship, I just
Your senior.
I just
It's
contacted
not
him
senior.
that we are going to have the hearing today.
I
was told that he's in hospital.
He's in hospital.
Yes, he met with an accident whereby
Okay.
he was needed medical attention.
When? Today? Yesterday?
Today, it will take some time, Lordship. In fact, the accident is a little severe. I told him to appear to BC since she is not the attached counsel. I would have helped him out in solving that issue, but he said he is not in position.
We are not inclined to allow the writ petition. At the same time, your appointment should also go. Anyway, what to do? MS so-and-so, learned counsel, appearing on behalf of Mr. This is what? Tosi Temjen Pongar. T. Pongenar. We can say T. Pongenar. T. Pongenar, learned counsel, were the petition submits that Mr. Pongenar had met with an accident today. Therefore, met with an accident who is under medical treatment. Therefore, prays for adjournment of the matter. Mr. MS so-and-so, learned State Council and Mr. Learned Council for Respondent number 3
6.
That's one number 6. No, you just said are present, huh? Have been considered that the Learned Counsel, Mr. Pongener, is under medical treatment and let this matter be listed after 2 weeks. Is it so serious?
Lordship.
Is it a serious accident? Then make it 3 weeks. 3 weeks. And item 7 will take up at 2. All right. Are you ready?
Yeah. More long, only to submit a letter. The petitioner gets all considered.
Okay. We'll take it up at 2.
For petition, item number 7.
Yes,
Yes,
Lordship. Yes, the petitioner case is under consideration as part of his direct 17.3. So if I may be allowed to submit this.
Yes. On this basis, we can close it since your case is under consideration.
Your worship, your worship.
So we'll close this.
Okay, your
We
worship.
don't have to direct them also. In view of this, we'll just close it. That will be better, right?
Lordship.
Heard, Mr.
Get to be your son.
Get to be. Get to be Jatso, learned counsel for the petitioner. And also heard Miss MS,
Pijanok Kitam for
learned
the state.
learned state counsel for state respondents. There's no private respondent. No. Next para. By filing this application, by filing this petition, the petitioner has prayed for a direction to the respondent authorities. To consider for regulation of his service as work church plumber helper under the executive under the in the office of the under the executive engineer, PWD within bracket housing division number 1, government of Nagaland. Mr. The next paragraph. Petitioner was appointed as work church plumber helper under the Department of Public Works within bracket housing in the office of executive engineer PWD within bracket housing division number 1. By an order dated 30/08/1994 with the scale pay of rupees. Where is your appointment?
30th August 19.
No, where is your appointment order? Appointment order.
Annex B, page 14 and 15, Your worship.
Yes.
Annex B,
Page 15, huh?
page 14 and 15. 14 is appointment order and 15 is type copy.
In the scale of rupees so and so, you just stated page 15. You have retired now.
No,
You-
not yet. Not yet.
How many years you have completed?
31 years, Your worship.
So, and is still serving after completion. Is still serving. and the department list of no, not still. He is serving as in the said capacity and the department list of. The case of the petitioner was recommended by the executive engineer PWD Housing Division number 1, Kohima, by letter dated 0409/2023 for regulation of the service of the petitioner, who has then completed 28 years of service as workers, plumber, helper. List of. However, same has not been considered. List of. It is the contention of the it is the contention of the petitioner that he has served for 31 years. No, he's serving as plumber, works as plumber helper for 31 years. List of, as per the office memorandum dated 17/03/2015 with regards to the scheme for regulation and absorption of workers and casual employees and revision of pay, public wages, the petitioner is entitled to be regularized as he has completed 30 years of more than 30 years of service as in today, service more than 30 years of service, continuous service. List of the clause 1/, clause 1 within bracket Roman small 2 bracket clause of the office memorandum indicates that in respect of those workers and casual employees in the scale pay and who have completed or will complete 30 years of continuous service after 01/01/2015, their cases for regulation will be taken up subsequently in 2 batches as on 1st July and 1st January every year. Mr. Since the petitioner has completed 31 years, he is entitled to be regularized. He is entitled for regulation of his service. Mr. The MS so-and-so learned State Council by placing the communication, a copy of the communication by the Engineer-in-Chief, NPW, the Government of Nagaland, dated 25/02/2026. Addressed to the petitioner, submits that the cases of regulation of service has been complied in the 8 page who have completed 30 years in service and above of the compiling list maintained by the department, which will be sent to the state government for consideration. And the case of the petitioner is under process. The regulation of service of the petitioner would be considered as and when his terms comes. Huh? As and when his terms comes, nah?
Yes, yes.
His turn comes. Mustafa. Having considered that the case of the petitioner is a case of the petitioner for regulation of his service is under process by the state authorities in terms of the office memorandum dated 17/03/2015 and as agreed to by the learned council for the parties, they considered the view that no useful purpose would be served in keeping the matter pending, as the case of the petitioner for regulation of his service is under process in terms of the office memorandum dated 17/03/2015. Accordingly, writ petition stands closed with an expectation that the case of the petitioner would be considered. A case of petition for regulation of service would be considered by the respondent authorities in terms of the office memorandum that is 17/08/2015 as expeditiously as possible. Mr. The writ petition stands disposed of. Well, simply say as expeditiously. That's all.